opening screen, the continuing resolution.
What is a continuing resolution? The definition that GAO provides in their glossary of budget terms is an appropriation act that provides budget authority for federal agencies to continue an operation when Congress and the President have not completed action on the regular appropriation acts by the beginning of the fiscal year. In order to put the continuing resolution in its proper context, we need to first understand that the federal government is supposed to be funded through 12 annual appropriations bills initiated in the House of Representatives, approved by both houses, and signed by the President before October 1st. But when Congress cannot get their appropriations work done in a timely manner, they use a continuing resolution as a fallback maneuver. That's why you frequently hear continuing resolutions described as interim, or stopgap, or temporary legislation. So that the primary reason for a continuing resolution is to temporarily provide funding until Congress can complete their work on appropriations bills. CRs are therefore necessarily restrictive. That is, the funding provided is generally the minimal amount necessary to keep the government running until Congress makes final appropriations decisions. There is a secondary purpose for continuing resolutions. They have been used as a vehicle for full-year appropriations. Since the Budget Act of 1974 was implemented, there have been 15 full-year continuing resolutions. But since these full-year CRs effectively become regular appropriations acts for the fiscal year, we will focus this discussion on the temporary or stopgap version. Before we get into the components of a continuing resolution, let's first review a bit of the history. Here's a look at what was purported to be the first continuing resolution, an act to provide temporarily for the expenditures of the government, that was passed in 1876. The continuing resolution legislation that we are familiar with didn't really begin to appear with regularity until the early 1950s. This may have been due to the fact that until the Budget and Accounting Procedures Act of 1950 tightened up the execution procedures in the Anti-Deficiency Act, federal agencies frequently spent funds on a deficiency basis, asking Congress for more money after the fact. Once the Budget and Accounting Procedures Act of 1950 passed, however, the rules got tighter, the penalties got tougher, and the Congress began to get more serious about passing interim legislation to avoid deficiencies. These bills were initially referred to as temporary appropriations until 1962, when they became known as continuing appropriations. We use the term continuing resolution because this type of legislation is most often passed in the form of a joint resolution. From FY 1952 to FY 1976, there was no year that all appropriations bills were enacted on time. So some form of temporary funding was needed each year. In those days, the fiscal year ended June 30th, so somebody in Congress got the brilliant idea that if they could just extend the fiscal year 3 months to September 30th, which they did in the Budget Act of 1974, they would be able to get all the appropriations done on time. The act was implemented for fiscal year 1977, and sure enough, Congress got all the bills appropriated on time for fiscal year 1977. Since 1977, however, there have been only 3 years in which all of the regular appropriations bills were enacted before the beginning of the fiscal year. In fiscal year 1989, 1995, and 1997. In fact, since the fiscal year changed to beginning on October 1st, there have been 164 continuing resolutions, averaging slightly more than 4 per year. This brief history points out that continuing resolutions have become a regular component of the appropriations process since the 1950s. Let's take a look at the component parts that make up a continuing resolution. There are 5 basic components. First, we'll go over them quickly, and then we'll spend a bit of time on each. First of all, you need to know the coverage of the CR. That is, which accounts receive funding. Second, you need to know the funding rate, or how much each account receives. Third, you need to know the duration. How long does the CR last? Fourth, you need to know the purpose and the restrictions, or the rules that you have to follow in spending the funds. And fifth, you need some fund accounting guidance to help you figure out how to record the operations under the CR. And while these are the basic building blocks for all CRs, you will inevitably have exceptions to these basic components that need to be spelled out. These are what we call anomalies. Let's take a look at each component in more detail. Building block number 1, coverage. Coverage tells us which accounts receive funding under a CR. Even the early CRs spelled out what was covered. Here in the 1950 temporary appropriation, we can see that any branch of the government for which appropriations would be made available for use in fiscal year 1950 by any appropriation act that is not law on July 1st, 1949, was covered. In 1961, Congress began to get a bit more specific with a list. Any projects or activities which were conducted in fiscal year 1960 and for which appropriations would be available in the following appropriation acts for fiscal year 1961, and they proceeded to list each act. Note the Department of Labor, Health, Education, and Welfare Appropriation Act. This listing became the norm, as we can see from Section 101 of the fiscal year 2014 continuing resolution. This act permits continuing projects or activities that were conducted in fiscal year 2013 and for which appropriations were made in a list of different acts. In 2013, HHS appropriations were made in the Agriculture, Rural Development, Food and Drug Administration and Related Agencies Appropriations Act and the Full Year Continuing Appropriations Act. Let me make a couple of points about the expression projects or activities. The meaning of the expression is contextual. In the coverage context, this expression, which has been in use at least since 1950, refers to the total appropriation in the previous year, not specific activities within accounts. However, later on, when we discuss the No New Starts provision, for example, the expression projects or activities refers to individual programs rather than a total appropriation. These contextual interpretations are well documented in Chapter 8 of GAO's Principles of Federal Appropriations Law, otherwise known as the Red Book, and are reiterated each year in OMB bulletins automatically apportioning funds under a CR. Building block number 2, funding rate. As a general rule, CRs do not appropriate specific dollar amounts. They appropriate such sums as may be necessary at a rate for operations. And then they proceed to tell you how to calculate that rate. You also have to pay strict attention because the funding rate could vary greatly depending on the status of your appropriation bill. For example, in the 1950 temporary appropriation, if the House and the Senate differed in the amounts provided in their bills, the amount provided was the lesser and more restrictive of the two. If only one House provided funding, the FY 1950 temporary appropriation provided an amount equal to the amount provided by the one House, but not to exceed the amount provided in 1949. In the 1961 temporary appropriation, we see the term current rate pop up as an option in the funding rate language. Let's spend a few minutes on this concept. Current rate began to be used to refer to the rate of operations carried on within the appropriation for the prior fiscal year. For a multi-year or no-year account, this rate of operations could include unobligated balances that might have carried over from the previous year. So the current rate would be equivalent to the total funds which were available for obligation in an account during the previous fiscal year. But suppose a multi-year account received an appropriation of $1,000 in the previous year, but did not obligate all the money and had carryover at the end of the year of $100. That would mean a continuing resolution using current rate would provide the $1,000 again. Coupled with $100 in carryover, the account would have $1,100 under the CR, probably more than Congress intended. In order to prevent this, Congress began to use the phrase "not in excess of the current rate" or "not exceeding the current rate," which would require you to subtract any unobligated balances available at the end of the year. To keep the account at the same level as the previous year, the CR would provide only $900, the $1,000 appropriation less the $100 carryover. This $900, coupled with the $100 carryover, would provide the same level of funding as the previous year and no more. Note in this example from fiscal year 2003 that Congress not only used the "not exceeding the current rate" language in Section 101, but they defined what they meant in Section 105. The term "rate for operations not exceeding the current rate" does not include any unobligated balance of funds carried forward. But beginning in fiscal year 2008, things got simpler. Congress dropped the old current rate terminology and simply referred to the rate for operations as provided in the applicable Appropriations Acts for the previous fiscal year. In this example, 2007. This format, which greatly simplifies CR funding rate calculations, has continued through to the present. We have OMB to thank for convincing Congress to simplify this calculation. In some cases, in order to make it clear what was available in the previous year, Congress will provide instructions reminding the reader to count any reductions or supplemental amounts that may have occurred in the previous fiscal year. For example, in the 2014 language, Congress starts with the amount appropriated in fiscal year 2013, but also includes the across-the-board rescissions in Division G and amounts sequestered. Making these calculations ensures the 2014 appropriation for discretionary programs under Section 101 of the CR is the same as the 2013 level. Prior to fiscal year 2004, funding for appropriated entitlements was not spelled out in continuing resolutions. Since these are calculated a bit differently than discretionary programs, starting with fiscal year 2004, appropriated entitlements got their own language in CRs. Entitlements and mandatory payments shall be continued at the rate to maintain program levels under current law. Fiscal year 2014 language is virtually identical to the 2004 language. As a matter of historical interest, referring to the action of the House and/or Senate or current rate as a reference for determining funding under a CR has virtually disappeared since fiscal year 2008. Building block number 3, duration. This section of the continuing resolution referring to duration has remained essentially unchanged since 1949. This section tells us how long we have to spend the money provided in the CR. There are 3 options. 1. Until enactment of a law providing funding for the accounts funded under the CR. 2. Until enactment of a law that does not provide funding for an account funded under the CR. Or 3. Until a specific date. Note the similarity in the 1949 language in 1961. And again in the 2014 version. If the date in option 3 is reached and no funding has been provided, Congress would need to amend the date to allow more time. Many CRs are simply one-pagers that amend this section. Here is an example that simply extended the FY 2001 CR by 8 days by amending the date in the duration provision from October 6th to October 14th. By the way, FY 2001 holds the record for the year with the most CRs, 21. One important point to remember: funds appropriated by the CR end on the date provided. They do not carry over, even if appropriated to a multi-year or a no-year account. Building block number 4, purpose and restrictions. The purpose and restrictions building block establishes the rules we have to follow in spending the funds appropriated by the CR. It's made up of 6 basic sections, separated into 2 major groups, old and new. In the old group we have extent and manner, authority and conditions, and the prohibition on new starts. In the new group we have the prohibition of high initial rates of obligation, the requirement to operate under the most limited funding action, and flexibility to avoid furloughs. Extent and manner language is the oldest CR language of the purpose and restrictions section. Here we see a sample in the 1950 Temporary Appropriations Act. Here's the 1961 version. And here is the 2014 version. Since the original purpose of the CR was to give Congress a little extra time to finish their work, initially most CRs tied the funding calculation to proposed bills that had not yet been enacted. Because these bills were expected to pass sometime in the near future, the language tends to be worded with futurity. to the extent and manner which would be provided by the Pertinent Appropriations Act. This is an example of incorporated by reference language. That is, the language refers to the words in some other bill and makes them part of the law by referring to them. This is a common technique with CRs. GAO opinions generally explain extent and manner as referring to fiscal matters like period of availability and account structure. Note that the fiscal year 2014 language still uses the futurity phrasing, to the extent and in the manner that would be provided by the Pertinent Appropriations Act, even though there are no future bills referred to. This seems to suggest that the language is a holdover from earlier CRs. But notwithstanding the futurity of the language, the current interpretation is that Pertinent Appropriations Act referred to is the relevant act from the previous fiscal year. Consequently, the interpretation of extent and manner in this case is that funds appropriated under the CR carry the same period of availability and account structure as their predecessor account. If the funds were multi-year in the previous year, they are multi-year in the current year. If they were no year, they remain no year. This might seem counterintuitive, that funds appropriated for spending for only a month or two might be classified as no year, but it's been determined to be the best reading of the language. Though it is my understanding this has caused some heartburn in OMB lawyers. Authority and conditions language is another example of incorporated by reference language. This phrase first appeared in the fiscal 1976 Temporary Appropriation Act and has continued to the present. Where extent and manner covers fiscal matters, authority and conditions covers program provisions such as the purposes for which funds are available or not available. This language has been interpreted to refer to the requirement that we have to follow the same conditions we had to follow in the previous year. Any earmark restrictions, any general provisions prohibiting funding for abortion, and so on. The prohibition on beginning new programs, or no new starts language, appears as early as 1954. Note that no appropriation shall be used to initiate or resume any project or activity which was not being conducted during the fiscal year 1954. Similar language continues to appear in the latest CR. Note, as I mentioned earlier, the expression project or activity in the no new starts context refers to individual programs rather than a total appropriation. This language tells us we cannot start any new programs while we're under a temporary funding scenario. Well, this seems logical. Under a CR, we're basically treading water until Congress decides how to fund everybody. It only makes sense that you would not start a brand new program during that time. I should point out that this does not mean you cannot, for example, give a grant in an existing program to a new recipient. It means you cannot start a brand new program. This language generally has much more of an impact on the Department of Defense than it does on HHS. This extent and manner, authority and conditions, and no new starts language has been appearing in CR since the earliest days. But the remaining rules were added a bit later. It used to be that an agency could obligate based on normal patterns, even under a CR. For example, one could make quarterly awards in a grant program if that was the normal pattern for that particular program, even if the CR only lasted for 1 month. In fiscal year 1995, however, Congress added language to prevent high initial rates of operation that would impinge on final funding prerogatives. And they felt the need to tell us to take the most limited funding action in implementing the CRs. The language continues in the most recent CR. This language is the primary reason why OMB has such strict rules for apportionment of funds under a CR. Furlough language first appeared in a CR in 1995 due to problems created by the limited funding in CRs. In that CR, the rate of operations could be increased to avoid furloughs. By fiscal year 2007, however, the furlough language changed to only allow OMB flexibility in apportioning available funds to avoid furloughs, but provided no extra funding. Note that there are very strict rules in its application. It can't be used until the agency has taken all necessary actions to reduce administrative expenses. This FY 2007 furlough language has continued to the present day CR. Block number 5, the rules on fund accounting. There are 3 fairly standard boilerplate sections that tell us how to account for our funding under CR. There's a section that ensures CR obligations are covered. There is a section that ensures the final appropriation structure shall be used from October 1 onward, the so-called ephemeral clause. And there is a section waiving apportionment due dates. First of all, there's a section that tells us that appropriations made in the CR cover all the obligations or expenditures incurred for a project or activity during the CR. Such a provision has been around in CR since 1954. This is the provision in the most recent CR. This can be very important because if Congress appropriated less in a full year appropriation than you were authorized to spend under the CR, this section could be cited to seek an additional warrant from Treasury to cover those obligations. For example, in fiscal year 2012, Congress appropriated less for a LIHEAP earmark than was obligated during the CR, and Treasury warranted the difference under this Section 105 authority. The second section that provides accounting guidance has been referred to as the ephemeral clause because of its temporary nature. Note the language from 1949. Expenditures shall be charged to any applicable appropriation or fund when the bill in which it's contained is enacted into law. This means that whenever a full year appropriation is enacted, all expenditures get charged to the applicable appropriation in the final bill. In other words, you act as if that appropriation was around since the beginning of the fiscal year, and all funds are charged as if it started October 1st. It's as if the CR is ephemeral and never happened. This is the language from 1952. And this is the current language. This language is necessary because there is a general rule of statutory construction that in the absence of explicit language to the contrary, a statute is effective on or after the date of enactment. Without this language, the appropriations made could not be applied retroactively. This section makes it clear that the statute is effective retroactively. This was particularly significant in fiscal year 2012 when HRSA SAMHSA, and CDC all had major account structure changes in the new appropriations actions, but had operated under the old structure under the CR. All obligations going back to October 1 had to be charged to the new structure. The last fund accounting section waives the apportionment submission requirements required by the Anti-Deficiency Act. This provision initially appeared in 1951, telling the agencies that expenditures from appropriations, funds, or authorizations made available pursuant to this joint resolution shall be available without regard to the time limitations set forth in subsection D2 of Section 3679 Revised Statutes. Some agencies read this waiver of apportionment time limitations as a waiver of the entire apportionment process and proceeded to obligate funds before Congress could reduce them in final appropriations actions. So, in 1968, Congress amended the language, adding, "But nothing herein shall be construed to waive any other provision of law governing the apportionment of funds." This amended version has continued to the present day. The Anti-Deficiency Act reference has, however, changed twice. Once from Section 3679D2 Revised Statutes to Section 665D2 of Title 31 United States Code, and finally to Section 1513 of Title 31 United States Code. Typically, OMB issues blanket apportionment authority in a bulletin and allows agencies to submit written apportionments under certain circumstances. We have discussed the 5 basic building blocks of a continuing resolution: coverage, funding rate, duration, purpose and restrictions, and fund accounting. We have seen that many of these building blocks are simply pieces of a jigsaw puzzle that get put together year after year with minor variations in some cases. But in any given year, there will always be exceptions, otherwise known as anomalies. While the basic building blocks vary very little from year to year, the anomalies can vary greatly depending on the circumstances. These may be exceptions to purpose, amount, and duration. For example, in 1974, during the Vietnam conflict, Congress used a purpose anomaly in a CR to prevent funds being spent to finance combat activities. In 1977, Congress used a purpose anomaly to prevent the use of funds to perform abortions. In 2000, there was a great concern that changing from 1999 to 2000 would wreak havoc with government computer systems. So a funding anomaly was used to provide funding for Y2K computer compliance. In the same year, a CR funding anomaly was used to provide funding for the decennial census, something that would not have been funded in the previous year. In fiscal year 2006, a funding anomaly was needed to provide for the new Office of Medicare Appeals and HHS. Since 2004, there has been a regular anomaly involving the duration of funding for entitlements. For example, in this language from the 2014 CR, there is an exception to the expiration date of January 15, 2014. Payments for entitlements and other mandatory payments can continue to be made for another 30 days past the January 15th limit in Section 106. For example, if you had a major entitlement payment due on February 1st, it would still be authorized even if the government shut down after January 15th. Note that anomalies are frequently started with the term notwithstanding. Using notwithstanding is like saying, forget what I told you about the purpose, funding, and duration in the earlier part of the bill. Here are some exceptions to that. So this represents the normal structure of a continuing resolution: coverage, funding rate, duration, purpose and restrictions, fund accounting, and anomalies. However, there are times when Congress uses the CR as a vehicle for certain legislative provisions. Under House rules, regular appropriation acts cannot contain legislative provisions. However, this rule does not apply to CRs. So we sometimes see the CR used as a vehicle for legislation. For example, on October 1st, 1990, a CR was used to pass supplemental funding for Operation Desert Shield. And on October 28, 1990, a subsequent CR authorized a temporary increase in the debt limit. In Division B, Other Matters, of the fiscal year 2014 CR, there's a provision on the verification of household income for the provision of Affordable Care Act subsidies. And there was also the provision for default prevention. Before I end this session, I want to discuss a frequent misconception about continuing resolutions. Is this statement true or false? The appropriation under a continuing resolution is the full annual amount. The answer is true. The appropriation is for an entire fiscal year. Why is that? Well, notice the language from the 1950 CR, making temporary appropriations for the fiscal year 1950. Same format was used in 1961 and all the years up to 2014. In the 2014, Congress added making continual appropriations for the fiscal year ending September 30th, 2014. This is probably one of the most common misconceptions about continuing resolutions. It seems counterintuitive that a continuing resolution that only lasts for a portion of a fiscal year would appropriate a full year's worth of money. But, in fact, the way we account for the money makes it very clear. Note that OMB guidance in Exhibit 120F of A11 shows an example indicating that you reflect the entire annual amount appropriated under the CR on line 1100 of the apportionment, and then subtract the amount that's not available or precluded from obligation on line 1134 of the apportionment. The Treasury guidance under a CR scenario tells us to first record the full year appropriation and then reflect the portion not available, all but 21 days in this example, as authority unavailable pursuant to public law. SGL account 4395 crosswalks to line 1134 on the SF-132, the apportionment schedule, and the SF-133, the report on budget execution. This is the correct accounting entry. But many budget offices simply enter the net amount of these two figures on line 1100. This concludes the session on continuing resolution. If you're interested in further study, I recommend the CRS report by Jessica Tollestrup, Chapter 8 of the GAO Red Book, and a GAO report on continuing resolutions. I also would like to thank Judy Thomas, an OMB expert on continuing resolutions, for many of the points made in this video, especially the concept of the ephemeral clause.
Closing screen. I hope you found this useful.